Hi guys, and welcome back to Contract B. This week is week 2, and this week we will be having a look at misrepresentation and misleading or deceptive conduct. The first 2 weeks of this unit, as you probably already realise, are fairly complex concepts that we cover, and this week in particular is a fairly heavy reading week. You'll notice that if you've picked up the text, you have a whopping about 96 pages to get through. Don't fear though, because it's all riveting reading, I promise. But what I've suggested that you do in the introductory video for this unit is that you break up the reading for this week over both weeks 2 and part of week 3. And what I suggest that you do is that you cover off around about 60 odd pages this week and then leave the other 30 pages for next week, because next week, yay, is a stopper, and it's only about 30 pages that you need to read for next week. So if you leave 30 odd pages there, it means you'll get a total of about 60 odd pages for week 3, which is more than manageable. It will also mean that in the 60 pages that you can cover for week 2, you will get across all of misrepresentation and most of misleading or deceptive conduct. Really, the last part of the chapter, those last 30 odd pages, are really just the finer points in relation to misleading or deceptive conduct, causation and remoteness, contributory negligence, and some other finer points like that. So you should still definitely be able to complete the tutorial problem for week 2 with the readings that I've suggested for week 2. So having said that, we will move on now to discuss misrepresentation. So what I'm going to do is pretty much what I did for the last week's material, and I will take you to Anthony's flowchart for this week, which is up on the Moodle site. It's nicely broken down. Again, it can be a little bit confronting when you look at it to start with, but as we unpack it, I'm sure it will all make sense to you. The first thing that you look at is whether or not there is an actionable misrepresentation. Now, in order to have an actionable misrepresentation, it will require essentially 3 elements: a statement of fact made at or before contract formation, and it is intended to induce and in fact does induce the other party to enter the contract. Now, the first element there, statement of past or present fact, that's not all she wrote on this particular issue. Certainly, statements of past or present fact, if they are misrepresented, will be actionable. However, the text does go through a number of other scenarios where you may potentially have an actionable misrepresentation. And the first thing it covers off is, what about statements as to a future state of affairs, a future set of facts, for example, or a future intention. Where those kinds of statements are made, usually a prediction or a statement about what might or might not happen in the future is not usually going to be actionable. However, if there is some basis in what is being said in existing fact, then it is more than likely a court will interpret that statement not as a statement of future intent, but as a statement of an existing state of affairs. So in the Balfour Clark and Hollandia case, you had a statement that a potential client of a building society, the Hindmarsh Building Society from Adelaide, where I come from, would be able to borrow a certain sum of money in 2 years' time. Now, you would think, oh, well, that's about something that's going to happen in the future, not actionable. Well, the court held no. In actual fact, that was a statement about the existing policy of the bank. Under the existing policy, yes, this particular client would be able to borrow this sum in 2 years' time. So, therefore, the statement was actionable. Likewise, if you are making a statement about what you intend to do in the future, it has been held rather delightfully that the state of a man's mind is as much a fact as the state of his digestion. That was a lovely sentiment by Lord Justice Bowen. Certainly a court will interpret your statement as actionable if you say that you intend to do something in future, but at the time you make the statement you actually had no intention whatsoever of doing whatever it was that you said. Likewise, where there's been a statement of opinion, something similar to a statement of perhaps your future intentions. However, here you have a slightly different set of surrounding circumstances sometimes, because your opinion when you state it may imply that you actually have some facts that would back it up. Now, where that's the case, the court probably won't let you get away with saying whatever you want to. Particularly, they look at things like the relative knowledge and position of each of the parties, the actual words used and the meaning of those words, whether there's any fraud hovering around in the wings there, and whether or not the opinion was stated, no matter how erroneous it was. And Bissett and Wilkinson is the case. I will leave you to explore that on your own. Similarly, statements of law. Are they actionable? Generally speaking, no. However, again, there's always an exception, isn't there? I mean, we're lawyers after all. So where you've got a statement of law made fraudulently or given in a situation that implied a duty of care to provide the correct kind of advice, or it's going to be unconscionable, in all of those situations you may find that a statement of law is in fact actionable. Statements of puff. Oh, what a lovely word. Brings back to mind Carlyle and the Carbolic Smoke Ball Company, doesn't it? From Contract A. Ooh, there's a case for you. Puffs, no, generally speaking, not actionable unless there's some kind of, intervention by the Australian consumer law, whether that puff has wandered into misleading or deceptive conduct. And now we come to silence. Is silence actionable as a misrepresentation? There's a couple of finer points here that we need to just cross off. Firstly, in relation to half-truths, you can't just go around telling the most favourable side of your story in order to induce a contract. If there is a half-truth that is stated, it will be actionable unless the qualifying facts are disclosed, okay? Similarly, where you have a statement that's been made and you've either found out that it's become false subsequently, or you've found out that it's been false all along, you actually need to go ahead and correct the misrepresentation that's ended up being made, so that the party that executes the contract is not labouring under any kind of misrepresentation. The other kind of silence that you might find is actionable is where there is a duty to disclose. Generally speaking, the law will leave you alone if you've been silent on a particular issue. Caveat emptor obviously applies, buyer beware. So you are entitled to keep mum generally, like we just saw, not if you've actually engaged in telling a half-truth, a bit of a half-porcupine, or in circumstances where you've found out that something's become false. But other than that, you are normally allowed to keep mum on things. But where there is a particular relationship at issue that would involve some kind of trust and confidence, then you do have a duty to disclose the full and unadorned truth of the matter. So we've got parties like principal and agent relationship, solicitor and client relationship, parent and child, trustee and beneficiary, or contracts ubere fide, of utmost good faith. These are usually insurance contracts where you have to actually spill the beans completely. This is your final category where silence may become problematic. So that's the first element. Has there been a misrepresentation? And we've looked at what kind of statements can wind up being actionable. Obviously, the statement has to be made to the other party to the contract that wishes to be released from their contractual obligations for this action to all hang together, and the text makes some mention of that. The next element that Anthony's got down here for us is that the misrepresentation must have been made at or before contract formation. This really just makes sense, doesn't it? Because if you're going to be complaining about a statement that was made to you in order to get you to agree to the contract, then the statement's going to have to be made either before you've contracted or at the time of contracting. So that really just makes sense. The other major element here is that the statement was intended to induce, and in fact did induce, the other party to enter the contract. Now, there's not normally going to be an issue with intention to induce. Normally when you're talking up a particular aspect of a contract or a deal, you'll be intending that that particular inducement has its proper effect on the other party, and they go ahead and sign on the dotted line. So intention's really not usually an issue. Reliance is, generally speaking, more of an issue. So yes, there's been the right kind of misrepresentation, it's been made at the right time, but was the misrepresentation relied on as one of the material factors that made the other party, made that representative sign their life away? And here we have an interesting case of Edgington and Fitzmaurice. And in that case, this was the main issue, whether or not there had been reliance or sufficient reliance on the misrepresentation. And it was held in that case that it didn't have to be the sole inducing factor for the representee to enter the contract. It just had to be an inducing factor, and that was brought out by the High Court further in Gould and Vagelos. It just has to be an inducing factor, a material factor for the representee to enter the contract, but just one of the factors that induced the representee to sign off. Now, in Gould and Vagelos, the High Court did actually say that where the misrepresentation was made and it was calculated to induce, it was intended to induce entry into the contract, and then the representee goes ahead and enters the contract, there is a fair inference that of fact that there had been sufficient inducement and reliance to pin the problem on the misrepresentation that was made. So that is the issue of reliance by the representee. Now, there are some circumstances where reliance may be put at issue, and that fair inference of fact that they mentioned in Gould and Vagelos might be debated somewhat. The first of these situations is where the statement is effectively ignored by the representee. Now, if that's the case, the representee can't then later allege that they've been induced to contract by this misrepresentation. The second one is where the representee has actual knowledge of the true state of affairs and they still go ahead and contract anyway. Again, that's not going to then allow them to later on go back and unstitch the contract because of the misrepresentation. The final issue in relation to reliance is whether or not a representee can be said to rely on a misrepresentation if they actually had the means of finding out that the misrepresentation was false. So they had access to the true facts. And here we have a nice little case called Redgrave and Hurd. The text doesn't really make much of this particular case, but it's an interesting one that fleshes out the concept. Here, another 19th century case. We have a solicitor selling his practice, and he's said that the practice brings in £300 per annum. He shows books that establish that the business brings in £200 per annum, and he says, oh, these other books and papers will establish the other £100. Now, if the purchaser had bothered to look at what was offered to him as an explanation for the other £100, he would have quickly found out that that wasn't established by those documents at all, and that there was a much lower income from the business. Now, the question was, did that misrepresentation as to the income operate as an inducement to enter the contract, given the fact that the representee relied on the misrepresentation without checking the facts, even though the means were offered to him to check those facts. And the court said, well, actually, you know what? It doesn't matter that he didn't go ahead and check those facts. We're still going to allow that misrepresentation to be actionable. Okay, so that is where you have the means of checking the falsity. It won't matter that you haven't gone and checked on the falsity or the truth of whatever has been stated to you. You will still be able to sue on the misrepresentation. So they're the three elements of misrepresentation. And what we need to look at now is the kinds of misrepresentation that can be made, because they will all have a very large bearing upon what remedies that your client can seek. Now, there are three kinds of misrepresentation. I'll just flip down here on the flowchart. So as you can see, there's innocent, negligent, and fraudulent. So I suppose that's kind of a sliding scale of naughtiness there for you. In terms of innocent misrepresentation, basically you define it by what it's not. It's not negligent misrepresentation, and it's not fraudulent misrepresentation. So what you're going to need to do is establish that those three elements here, your statement and the time of making the statement and the inducement and reliance are all present, and that in terms of the other two categories, there's no negligence involved and there's no fraud involved. Now, in this particular case, pretty easy peasy. Once you've established those three elements, your main remedy is going to be rescission. As you can see there, you just want to get out of that darned contract, okay? You cannot get damages for this particular form of misrepresentation. I know it's the damages box is right next to the rescission box, but as you can see, there's no nexus between the two, and there's certainly no availability of damages there. So rescission will be possible where there is no subsequent intervention of any of those factors that I mentioned to you in the week 1 video on remedies that would destroy your right to rescind. So you need to be able to have here the possibility of restitutio in integrum. You need to get those parties back to substantially the same positions that they had before they contracted. And there mustn't have been any affirmation or any of the other factors like latches, where the innocent party just sits around on their rights and twiddles their thumbs, doesn't do anything, and then years later decides to try and exercise their right to rescind the contract. Third-party rights. So when we were looking at the cases involving the rogues, if a third-party right has intervened, as I said before, this is an equitable remedy. So the remedy of rescission will actually yield to the perhaps more innocent rights of the third-party intervener. Likewise, if the contract has been completely performed and executed, done, dusted, big tick in that box, then you can't turn around and try and unstitch it all. So that is the issue of intervening factors that might destroy your right to rescind. If there are none of those present, then rescission might be granted. Okay, so then we move on to negligent misrepresentation. And negligent misrepresentation, for those of you that have done torts, I would gather probably most of you have done torts by now. You know that there are three fairly familiar elements to establishing a case of negligence. There has to be a duty of care. There has to be some kind of breach of that duty. And then there has to be some kind of loss. No real different here. So the thing that the text kind of takes some time to elaborate on is that there must be a duty here. And this is where the notion of a special relationship between the parties arises. There will be an assumption of responsibility and therefore a duty of care where the representor realises or ought to realise, so there's that little reasonable person test creeping in there, that they're being trusted to give information of a kind that will be acted upon by the representee. And then the representee actually does go ahead and act upon that information reasonably. So that's the kind of special relationship that will usually give rise to some kind of duty of care to take reasonable care that the statements that you are making are true and reliable. In terms of breach, no real rocket science there. However, in terms of loss, you will again note that from torts, there needs to be sufficient causation, and the text just steps you through the issues of causation and remoteness and so forth. Pretty much runs along the same lines as what you will have learnt in negligence. So here, if you can establish your negligent misrepresentation, you've got your three elements that we looked at before. You've got your extra elements establishing negligence in this particular matter. Then you go down according to the flow chart, and you can get rescission of your contract, but you can also get damages, and these will be measured as damages for the tort of negligence. Okay, so the object of damages in negligence will be, as with all torts, to try and get that plaintiff back into the position as though the tort had not occurred. So they will be compensated for their reliance on the misrepresentation where it has caused them loss. Okay, now as you can see here from the flowchart, only for negligent and fraudulent, and it's cumulative, not sole. So you can get out of your contract and also be compensated for any out-of-pocket expenses that you've got in order to get you back to that pre-tort position that you were in. So there you can see the object of those damages there. Finally, we have fraudulent misrepresentation, and this is the extreme naughty end of what representors might say. So again, you need to establish your three elements up the top there to show that there is actually an actionable misrepresentation, plus you need to establish fraud on the part of the representor. And this will usually arise where, the most obvious kind, the person knows that they're lying. They know that they're telling a porcupine, and it's apparent from the circumstances that that was the case. The second kind of evidence that will point to fraud will be where somebody makes a partial statement which has the effect of conveying a falsehood, kind of like where you're telling half-truths, where silence is an issue. If you're going to say something in pre-contractual negotiations, better make sure that whatever you say is pretty much 100% true. If you start telling half-truths or partial statements, it's going to get you into trouble. The third kind of indicia of fraud is where you just don't care. You know, might be true, might be false, sounds good, so you say it. Again, not good enough, the court says. If you're going to actually go to the bother of saying something, it'll have to be true. Finally, the party doesn't believe in the truth of their statement. So all of those kinds of indicia will add up to fraud. And as you can see, you've got this block down here which says have a look at what kind of fraud it is, and then if you follow the arrows along, you will see you can get rescission, you can get out of that contract, or you can get damages. Now, damages here will be in the measure of the tort for deceit. So again, because it's tortious damages, the object is to get that party back into their pre-tort position. Okay, you're not going to make money out of this. It's very different to contractual damages. You're not going to get anticipated profits. You're not going to get expectation loss. You're just going to get enough to put you back into the position before the fraud occurred. Okay, so they are the three kinds of misrepresentation, and that is misrepresentation in a nutshell. If you have any questions or queries, like I say, just send me an email, tweet me, post a message on Facebook, and we'll try and clear up whatever comments that you've got. Otherwise, you can post to the forums on Moodle. And apart from that, I hope to see you in the Zoom session for this week. The next video will be on misleading or deceptive conduct, so I look forward to seeing you then. Thanks. Bye, guys.